Welcome to Immigration Talk with Attorney Anish. Attorney Anish is an immigration lawyer who has been certified as a specialist in immigration and nationality law by the State Bar of California's Board of Legal Specialization.
Hello, everyone. This is Attorney Anish, and you're listening to Immigration Talk with Attorney Anish. Today is February 22nd, 2019, and a topic I've been receiving a lot of questions about is the VAWA Abused Spouse Self-Petition. VAWA stands for Violence Against Women's Act. The Abused Spouse Self-Petition, also sometimes called the I-360, is for people who want to obtain their green card here in the United States, but do not want to rely on their spouse to petition for them because their spouse has been abusive toward them, either physically or emotionally. My office handles a number of VAWA Abused Spouse Self-Petitions, and over the years I've received many questions about them, and a lot of these questions are the same. And so I wanted to discuss some common questions that people tend to ask about the VAWA Abused Spouse Self-Petition. And of course, the number one question I always get is, will my husband or wife, meaning the abusive spouse, know that I filed? Now, under VAWA USCIS, and more specifically the USCIS Vermont Service Center, which handles all the VAWA Abused Spouse Self-Petitions, cannot contact your spouse to inform them that you have filed an Abused Spouse Self-Petition. In fact, the Vermont Service Center goes to extraordinary lengths to ensure that the confidentiality of the Abused Spouse Self-Petition is not leaked to the abusive spouse. Some of the precautions taken include ensuring that all the receipt notices and any other notices or communications from USCIS regarding the VAWA Abused Spouse Self-Petitions and any applications or filings relating to it are not sent to the home address, just in case the petitioner is residing with the abusive spouse still. And instead it goes to a safe mailing address, whether the attorney's or any other safe mailing address that the petitioner wants to use. So, unless the petitioner informs the spouse or one of their friends or family members or the attorney, and I would never do that, there is no way for the spouse to find out about the Abused Spouse Self-Petition having been filed for or by the petitioner. So I just wanted to make that clear. There is also, similarly, there is no requirement that you report the abusive spouse to the local authorities or to any other law enforcement authority. This is not a U visa. While the evidentiary standard for both the U visa and the VAWA Abused Spouse Self-Petition is any credible evidence, unlike the U visa, there is no requirement to prove that there was any type of law enforcement action, whether investigation or prosecution. It of course helps if there was one, but it's not required. Similarly, there are no requirements that there be any medical records. If there are, then we would like to include them, but if there are not, then you can still otherwise prove that there was abuse, even without the medical records and even without any type of law enforcement activity. Another question I commonly receive is one relating to whether or not the Abused Spouse Self-Petition can be filed for someone who is outside of the United States. Just like any immigrant petition, it can be filed with the Vermont Service Center, but like any other immigrant petition, it can be filed whether or not the beneficiary is in the United States or outside of the United States. The difference is if the beneficiary is in the United States, and in this case, because it's a self-petition, both the petitioner and the beneficiary are the same person, then the beneficiary can apply for the green card in the United States, a process known as adjustment of status. If the beneficiary is outside the United States and has no way of entering the United States, then the beneficiary can apply for an immigrant visa abroad called consular processing, and then upon entry they will be a permanent resident. So I hope that clarifies things, that it doesn't matter where you are in the world, you can still pursue an Abused Spouse Self-Petition. Another question I receive is, do I have to divorce my spouse? No, there's no requirement that you divorce your spouse. A similar question is, do I have to move out? No, not required. You don't need to move out from the same home in which you reside with your spouse. The dynamics of abusive relationships sometimes would guard against that until there's some kind of stability in the person's immigration status. we don't want any scenario where the abusive spouse can find out what's going on and target the self-petitioner. Now, one thing to note that is, if you do get divorced, then the self-petition must be filed with USCIS within 2 years of the divorce becoming final. Otherwise, the abused spouse self-petition is not an option. Similarly, if the abusive spouse passes away, then the abused spouse self-petition should be filed within 2 years of the abusive spouse's passing. So that's important to note. Another question I receive is, does my abusive spouse have to be a U.S. citizen? No, it's not required. The abusive spouse can be a permanent resident or a U.S. citizen. If they hold neither status, then there may be an exception wherein the abusive spouse obtained LPR status after, or will soon obtain LPR status. And then we'd have to discuss whether it's wise to file now in anticipation of the abusive spouse receiving LPR status. And when I say LPR status, I mean Lawful Permanent Residence, also known as a green card. Or if you actually want to wait to see if such status is first obtained before filing the abused spouse self-petition. There's a lot of moving parts. So, for example, if one wants to wait for the spouse to become a permanent resident first before filing the abused spouse self-petition, but at the same time the divorce has already become final, well then we need to make sure that that abused spouse self-petition is filed within 2 years of the finality of the divorce, regardless of the desire to wait until the abusive spouse becomes a permanent resident. Similarly, if the abusive spouse has lost permanent residence because of having been deported, then the self-petitioner does not lose eligibility. What does cause a self-petitioner to lose eligibility, and this is another question, and this question refers to another common question, and this refers to remarriage, is if the self-petitioner remarries before the self-petition is approved. So the self-petitioner is married to an abusive U.S. citizen or permanent resident, divorces that abusive spouse, files an abused spouse self-petition, an I-360, is waiting for a decision, but then in the meanwhile remarries before a decision is made on that abused spouse self-petition. Well, that just kills the abused spouse self-petition. That ends eligibility. If, however, the self-petitioner waits until the abused spouse self-petition is approved and has still not yet received a green card based on that self-petition, that's fine. The self-petitioner can go ahead and get married after the self-petition has been approved. That's very important to note regarding timing of remarriage. Now, other questions I receive about the abused spouse self-petition is, do I need to prove lawful entry in the same way I would normally have to prove it in a regular marriage case? No, it's not required. USCIS will permit someone to adjust status in the United States through an approved abused spouse self-petition, even if that self-petition does not have lawful entry. Now, when I say lawful entry, I mean a procedurally regular entry. There are other grounds that can render someone to be ineligible for adjustment of status even through VAWA abused spouse self-petition. And it's important to note that some of them have waivers and some of them don't, and in certain circumstances the waivers need certain things to be proven. For most of the waivers, the general requirement is that the ground for inadmissibility, whether it be a criminal conviction or it be fraud or willful misrepresentation, or it be prior deportation or prior removal, that such grounds for inadmissibility are tied to the abuse in the relationship, are tied to the very abuse in the relationship through which the self-petitioner is seeking to have the abused spouse self-petition approved. However, certain waivers, even without being able to tie the grounds for inadmissibility to the abuse, can still be granted based on extreme hardship to the self-petitioner or the self-petitioner's children. But one ground for inadmissibility in particular, which is the illegal reentry, meaning the illegal reentry after either a deportation or after either having triggered an unlawful presence bar, that illegal reentry must be tied to the abuse for it to be waivable. If it's not tied to the abuse, then it's going to be a ground for inadmissibility that cannot be waived. And while the self-petition can be approved, the adjustment of status or the green card, that part cannot be approved. And so the ultimate goal is not achieved. And that's something very important to note, that if there are situations where there are deportations either at the airport or at the border or or based on an immigration judge's decision, that if we want to, and then there was a subsequent illegal reentry, meaning the person came back into the United States without authorization, despite that removal order. Or on the other hand, if someone was here unlawfully in the U.S. for a certain period of time, whether it's more than 6 months but less than a year, or even more than a year, then departs the United States and then illegally reenters. For those grounds for inadmissibility to be waived, the illegal reentry must be a result of the abuse in the relationship. That's very important to note. So there are waivers, but each waiver must be looked at a little bit differently depending on the circumstances. And however, what's good about the VAWA abuse by self-petition is that if, on the other hand, if someone was trying to get their green card through marriage to a U.S. citizen, through the normal I-130 adjustment, marriage-based green card case, then illegal reentry is not waivable. And the person would have to, in most circumstances, be outside the United States for 10 years before they can even apply for a waiver. And that is a huge problem for the normal marriage-based green card cases. And is the reason why a number of people are denied at the embassy or the consulate during their interviews, despite even possibly having an I-601A provisional unlawful presence waiver granted for them, because USCIS, when they granted that provisional unlawful presence waiver, didn't know about the illegal reentry. So moving on, one other common question I get about the VAWA abuse spouse self-petition relates to the ground for inadmissibility for false claim to U.S. citizenship. Now, a false claim to U.S. citizenship is still a bar to adjustment of status, even for someone who has an approved abuse spouse self-petition. And claiming that the false claim was the result of the abuse in the marriage is no excuse and is not a ground for a waiver. If one has that type of negative immigration history, then it needs to be analyzed very thoroughly to determine whether or not what actually happened does meet the definition of false claim to U.S. citizenship. Because even if there was a claim to U.S. citizenship, it may not meet the legal definition under the immigration laws of a false claim to U.S. citizenship, and all the facts would have to be determined before deciding to move forward with adjustment of status based on an abuse spouse self-petition. Now, even with the false claim to U.S. citizenship, there may be other avenues for relief, possibly a VAWA cancellation of removal, which is only available in immigration court, but that's a different topic. Similarly, a finding of marriage fraud in whether it's the same marriage or a prior marriage, would be a ground for denial, not of the adjustment, but of the self-petition itself. So, under Section 237, if someone has been found to have committed marriage fraud, they are deportable. Similarly, under Section 204, someone who has been found to have committed marriage fraud, even if it is not in the marriage through which someone is claiming abuse, but it was in a prior marriage, that finding of marriage fraud can be used to deny any immigrant petition, including a VAWA abuse spouse self-petition. And if the self-petition cannot be approved itself, then there is no adjustment of status, because there's no petition on which the adjustment of status can be based. So that also has to be analyzed and confronted when preparing an abuse spouse self-petition, because if one has been in a legitimate abusive relationship, a marriage, but there was a prior marriage that USCIS is considering to be a fraudulent one, meaning one that was entered into solely to evade the immigration laws, then that fraudulent marriage, or that marriage that's perceived to be fraudulent, will be a bar to having the abuse spouse self-petition approved, even if the abuse spouse self-petition is otherwise approvable. And that's a big thing to know. So there are a number of issues when it comes to abuse spouse self-petitions. I think the final issue I want to discuss when it comes to the abuse spouse self-petition is similar to what we discussed a little bit earlier in the show, and that's relating to the evidentiary standard and what needs to be shown to prove abuse. Because a common question I have is, I have no evidence, I have no evidence, I have no evidence. So how can I go ahead and show that what happened to me actually happened? And what listeners need to understand is that your testimony, your sworn declaration, is evidence. And the any credible evidence standard that applies to VAWA abuse spouse self-petition essentially looks at all of the facts and records that are available to USCIS to see whether or not the declaration and the claim by the self-petitioner is consistent, both internally, meaning within the self-petitioner's own documents and statements, and externally, meaning outside of that, what USCIS is able to gather. If that internal and external consistency is established, then the self-petitioner has to be found to be credible. And if the self-petitioner is found to be credible, then USCIS will believe every assertion the self-petitioner states, and then the only issue largely becomes whether or not what the self-petitioner has stated meets the definition of abuse, which is defined as physical battery or extreme cruelty. What are some other issues relating to VAWA abuse spouse self-petitions? Bigamous marriages, where the marriage was not legal because the abusive spouse was already legally married to someone else, and maybe the self-petitioner didn't know about it. There is an exception, and someone can still get an abuse spouse self-petition approved in such a scenario. Good moral character is something very important to consider, especially in certain circumstances where the police were called and the self-petitioner was arrested. Not something that needs to be confronted, because the normal rule is that the self-petitioner needs to prove 3 years of good moral character during, and that 3 years runs backward from when the self-petition is filed. And that's something also that should be taken into account, because maybe if there is a conviction, then potentially you may want to not file the self-petition immediately if it's going to trigger a finding of not being able to prove good moral character, while also taking into account that if there is a divorce, then the self-petition still needs to be filed within 2 years of the divorce becoming final. And so sometimes there's a very narrow window or no window at all, and that needs to be analyzed as to what the best approach is. The common practice, or the standard practice right now for USCIS, is that even if there is a ground for finding that someone has not been able to maintain the requisite good moral character, if there would be a waiver otherwise available to that person for that activity that's causing the finding of a lack of good moral character, then USCIS should exercise its discretion in a manner that does not find that the person has not been able to prove good moral character, and basically defer that decision for the waiver at the adjustment of status phase. And so not every basis for a lack of good moral character is waivable. For example, habitual drunkard is not a waivable ground, but even an aggravated felony can be waived by Section 212H if it meets the requirements. And so that theoretically should be found not to be a ground for finding a lack of good moral character, even though an aggravated felony usually is a permanent bar to finding good moral character. So good moral character and inadmissibility are two different things, but if there's a basis for finding that someone doesn't have good moral character, but it's otherwise subject to an inadmissibility waiver, then oftentimes the self-petitioner can still get the self-petition approved, but then we'll still need to show that the waiver should be granted. Anyway, I hope that shines some light on the VAWA abuse spouse self-petition, because I do get a number of questions on these self-petitions from all over the world, and I don't want people to think that they're somehow foreclosed from pursuing such an important ground for relief, when in fact they may be eligible and meritorious. A final thought is that during the shutdowns, there have been a lot of conversations about VAWA not being funded. The VAWA abuse spouse self-petition still exists. It's still good. USCIS is still adjudicating them, and they're still approving them. So I don't want people to think that it's not an option anymore. And if you have any other questions in particular, please contact my office. And I hope everyone has a very good and safe week.